Welcome, everyone. Thanks for joining us today. Just seeing people just kind of come in from the waiting room, so we'll give just another minute or two until we get started here. All right, thanks. We'll go ahead and get started. Had a good number of folks that have been able to join us. Thank you for joining us. And yeah, let me post the a translated version of our slides this morning. Let me find that where. Try that again. There we go. So I just posted in the webinar chat a PDF of our webinar translated into Spanish, people who'd like to follow along in Spanish. Just a little background. So this is, I'm Deepak Mandala. I'm with the Virginia Poverty Law Center. And I'm also joined today by Ben Devanzo from the National Immigration Law Center. Very happy to have him joining us this morning, and a big thank you to them to kind of introducing us to this new updated rule for Section 1557 of the Affordable Care Act. But just a little introduction. So I'm from the Virginia Poverty Law Center. If you don't know who we are a program here based in Richmond, Virginia, and we kind of work on a lot of different topics, but one important thing is we do a lot of work in healthcare access and helping to get people connected to health coverage and different forms of health coverage. And this topic is quite important to us because it is, we have found over the years, especially in Virginia, that language access is one of the key barriers to people both accessing health coverage and then using that health coverage to address their healthcare needs. This is just an overview of our kind of webinar today. First, we'll kind of just go over some housekeeping rules and some notes on how the webinar will work. I'll just do it in just an overview of the rule itself and the rulemaking process. Ben will go into more detail about language access specifically under the updated 1557 ACA rule. And then we'll have some time for a Q&A at the end and comments. So on the webinar today, there's no, we'll be able to chat with you. So I'll be sending messages from time to time through that feature. It's disabled for attendees to use the chat, but the way that you can communicate with us is through the Q&A feature. So you can use the Q&A to submit questions to us, and we'll be answering those as we go along. We also have on today's webinar a Spanish language option. So if you click on interpretation and then choose Spanish language, Amber Perron, who is on our team, has graciously offered to interpret the entire webinar for us today. So thank you to her for doing that. And also you can follow along with the Spanish version of the slides. And with that, we'll go get started. So first, I just want to just give a little bit of background on kind of just the rulemaking process and, what is Section 1557 generally, and kind of why there's a new kind of updated rule coming out now. One key piece here is that, why language access is so critical to particularly Virginia. One thing is that, in really just the last 2 decades, the population of, immigrants has really exploded in Virginia. If you actually go back another 10 years before that, up until now, it's really just even more than that, but it's just doubled in the last 20 years. Now we have over 1.1 million foreign-born residents, and of those, about 40%, according to a recent census, are limited English proficient. And according to the same census, it's a quite broad variety of different languages that Virginians do speak at home. So of course, Spanish is one of the largest ones, but we also have a significant populations of Koreans, Vietnamese, Chinese, Arabic, Tagalog, Persian, Amharic, Urdu, and French, and many other languages as well. Including what we've seen recently, a high number of immigrants coming from Afghanistan and Ukraine as well. So just a couple of months ago now, just on May 6th is when HHS published a brand new rule on Section 1557 of the Affordable Care Act. And Ben will go into more details on the language access part of this rule, but generally this section is the part of the ACA which prohibits discrimination on the basis of all protected categories. So that includes race, color, national origin, sex, age, and disability. And an important note there is that it also includes that any combination thereof, and that is because 1557 also recognizes that people often experience discrimination based on more than one protected category. So that's the intersectionality of the discrimination, and that's that any combination thereof. So this part of the rule, has actually been in effect since the ACA became law on March 23rd, 2010. So it's almost 10 years in effect. However, and the Office of Civil Rights out of HHS has been enforcing this section and investigating complaints, but the interpretation of the statute itself has evolved over time. So when the rule first came out, the Obama administration at the time did undergo a pretty extensive process to develop the first rule. So that first rule came out in 2016, but they did undergo a request for information, a proposed rulemaking process with comments, and then finally issued the final rule. So it was an extensive process, and that rule did include protections against discrimination on the basis of sex. That includes sex stereotyping, gender expression, gender identity, termination of pregnancy, and it also included some new protections for LEP at that time. Then in 2020, so this was under the Trump administration, a new version of that final rule was issued for 1557 that eliminated many of those 2016 protections. So one thing that this new 2022 rule does is to restore, kind of revising the rule to kind of get it back into better alignment with the actual statute itself of the ACA, so the statute that was from 2010. It also kind of better reflects recent Supreme Court decisions that came out after 2020, specifically on the kind of clarification on what discrimination of sex means, and to include sex discrimination on the basis of orientation and gender identity. The new rule also is addressing some of the things learned about kind of issues raised, particularly in the public health space when it came to the coronavirus pandemic and who was impacted and how certain people were kind of impacted in a more difficult way because of some of the protections around LEP specifically. So we've posted a couple of resources here on kind of there's the link there to the rule itself, and then also HHS put out some fact sheets and Q&As that go into more detail on the rule itself. And with that, I'll turn it over to Ben to kind of go in more depth on the language access pieces under this new final rule.
Thanks, Deepak, and I'll just say next slide when it's time to go to the next slide, which is now. So my name is Ben Devanza. I'm Senior Health Policy Strategist at the National Immigration Law Center. We're a national advocacy organization, and our focus is around low-income immigrants. We do policy analysis and impact litigation, so I'm on our policy and advocacy team. But we work on many different issues, everything from health to education to labor rights to, of course, immigration policy and education. I myself live in Arlington, Virginia, so I am a Virginian as well. And I'm here to talk you through some of the weeds around the language access portions of the Section 1557 rule. And my goal really is to help you all understand people who are much closer to people who might be impacted by language discrimination, what it might look like for someone's civil rights to be discriminated against in order to potentially either file a complaint with a health provider or a hospital system or with an Office for Civil Rights to address that and get them remedied. Next slide. So going into exactly where, like who is covered by this rule, and we say Section 1557, but that's such a wonky term. I prefer, and others as well, say the healthcare rights law. Really prefer to talk about, who is impacted by this, and I should say many of these are not actually new protections. So Section 1557, what takes its authority from Title VI of the Civil Rights Act, which is, of course, from the 1960s. And so we're actually, since 1964, we're at the 60th anniversary of many of these protections being in place, and they've long applied to any recipient of federal funding. So any entity that receives grants from the federal government or contracts or anything like that, they're getting taxpayer money, they're covered by the Civil Rights Act. And by extension, therefore, Section 1557, which really specified and clarified that these rights apply to recipients of healthcare funding, as well as activities by the federal government that are health related. So more specifically, right, who are these rules apply to that I'm about to go through? And I'll go through the rules after, of course, we go through this page. So hospitals, medical practices. So that means if someone goes to the emergency room or goes to the doctor, or goes to anyone that receives Medicare or Medicaid or any sort of government or public assistance plan, at least funded by the federal government, which is the vast majority of doctors and the vast majority of hospitals and health practices, is even if they receive any sort of Medicare or Medicaid funding or other federal funding, this applies to them. And to clarify, this does not mean the patient needs to receive Medicare or Medicaid funding. So if you have someone with private insurance, they have the same exact rights. This is about who this applies to. This includes the healthcare marketplaces. And so that means in Virginia, right? This is the first year that Virginia is going to have its own marketplace. And so Virginia's marketplace, as well as Virginia's Medicaid system, has to abide by these protections. Insurance companies. So if you're an insurance company that sells plans on the marketplace, or if you're an insurance company that has a Medicare Advantage plan or a Medicaid managed plan, which again is the vast majority at this point of insurance companies, these rules apply to you. And also, it's not listed here, but state public health departments, or recipients like nonprofits that receive grants or universities that receive healthcare funding. Many entities are after by these requirements. And so odds are, if you are in a healthcare situation, that the practitioner or the person that is providing healthcare or a health service is probably going to be in some way or other covered by Section 1557 or the healthcare rights law. Next slide. So briefly, as Deepak mentioned, this law is not just about language access. It covers sex discrimination. And in fact, that is the part of the law that has received a lot of the national attention because it includes discrimination on base of sexual orientation and gender identity. So I've been in meetings with civil rights staff at the Department of Health and Human Services and heard folks in the transgender community share pretty horrific stories about doctors misgendering them or asking really invasive questions, and those are not allowed under this law. Similarly, people who have disabilities, so discrimination, people who have either physical and mental impairments, and there's actually a lot of overlap. I'm going to be focusing on people with limited English proficiency, but people with communications related disability, people who have vision issues or hearing issues or use alternative means of communications due to mental disabilities are covered by this. And so that includes, for example, I'm going to be talking about interpreters, but it also includes ASL interpreters or providing information in Braille. So this is a rule that goes beyond just language access, even though that is the focus of this presentation. Next slide. So national origin discrimination is sort of the legal requirement here. So what the Civil Rights Act of 1964 says, therefore the Healthcare Rights Act, is that recipients of federal funding, or in this case, healthcare funding, or the federal government's healthcare programs cannot discriminate against someone's national origin. So that means in a really basic way, like you can't say, well, I'm going to provide medical services for someone from this country, but not that country. But in its kind of most significant way, in the way we're going to talk about today, it means that you can't discriminate against someone because of their preferred language. And if you do, if you are not providing services to someone in a way that allows them equal access to those services, even if they speak a different language, that is national origin discrimination. However, then this becomes very nuanced, because exactly what is equal access? What does it mean for what steps are required? And this rule provides some, but not necessarily all, the clarification you might want about what sort of access someone is required to provide in order to meet the civil rights requirements. Next slide. All right, so what are the base language access requirements? And these are really the ones that have been long-standing, that have been, Department of Justice for decades has kind of provided these base requirements. But it's that, so a covered entity, and as a reminder, when I say covered entity, I mean someone who receives federal healthcare funding, or the federal government itself in terms of its health programs, must take reasonable steps to provide meaningful access. And those terms, reasonable steps and meaningful access, are not necessarily defined. These are not defined in law. And for a long time, they have not really been defined in regulation. Court cases, practice, civil rights review have kind of helped to define the contours of what those terms mean. But it becomes really difficult if you or someone in your family or someone in your community is not sure if they're being discriminated against. That can become challenging. And so some of our hope with this new rule is that both it provides more certainty for what is and isn't discrimination, as well as provides some basis to make those rules maybe stronger or provide even more details. Because I imagine you all are going to have potentially questions, or at least I've seen questions in other webinars about other kind of specific circumstances, and I'll answer them to the best of my ability. But a lot of the time is, well, we'll have to find out. The really great thing about this new final rule that was not in the original Obama era healthcare rights law regulation, nor in the Trump one, is that it also explicitly covers companions with limited English proficiency. And that is so important for kids, right? There are many, many children who themselves are English proficient, but whose parent is not, whose parents are not limited, who parents or guardians, I should say, or grandparents may be bringing them to school, to the doctor's office, and they are not proficient in English. And so this covers providing them with meaningful access. And so really the two basic ways, right, we mean when we see language access, it's oral interpretation. So, right, that's someone verbally providing something in language, usually live. So having someone there when your doctor's providing a diagnosis, for example, and that person is providing the diagnosis in the language, or document translation. And so that's, let's say you get a letter from your insurance company saying that you haven't paid your premiums and you're about to be terminated from your health insurance. That would be translation if that is put into another language. So I'm going to kind of go into detail about when and how those are supposed to happen. So next slide. All right, so interpretation we have seen, and probably many of you have experienced, is not always provided in a way that is quality or a way that really meets people's civil rights. And so an important step provided by the regulation is that further defining who must be providing interpretation or who must be providing information in language verbally. And the terminology used in this rule, and this is not a new part of it, but we get some more clarification, is a qualified interpreter or a qualified translator. And a qualified interpreter or qualified translator does have a definition, which is actually an important, great step. And it must be someone who is proficient in the relevant languages. So, for example, a interpreter providing Spanish interpretation must be proficient in both Spanish and English. They have to be able to use specialized vocabulary, which is really great because so that means if, for example, that Spanish interpreter is providing interpreting for a diagnosis for a cancer specialist, they have to know the word cancer or the word metastasis. I'll use a different metastasize. Thank you. Uh, in Spanish. And if they don't know that word in Spanish, then they're not qualified, and that could be a civil rights violation. And they must adhere to ethical standards. And I will say the rule does not say how that proficiency has to be measured, exactly what type of specialized vocabulary is to be expected, or exactly what those standards are. And I'll say a question I often get is, well, does that require interpreters or translators to be certified? There are certifications for interpreters and translators, and there are certifications for medical interpreters. And the answer is no. That is something that is not required by this final rule. It's something that we had recommended, but a hospital or a program hiring interpreters or translators does not have to make sure they're certified. They could do their own ways of testing whether someone is proficient. I'll also say this mentions bilingual staff, right? So in language information could be provided not by an interpreter, by, let's say, a doctor or a nurse who is themselves multilingual, who speaks Spanish, for example. But that staff must meet those same qualifications. So you can't have someone, let's say, someone was raised by their parents and they spoke Spanish at home casually, but maybe they weren't trained in Spanish. That person might not be a qualified bilingual staff if they're not trained to provide medical information in Spanish. And that's a pretty important distinction because I think we see that happen pretty often. Nor is it allowed to use a staff member who is not an interpreter to interpret. So let's say a doctor has a front desk staffer, an intake person, or even a nurse or a medical assistant who speaks Spanish. Unless that person is a qualified interpreter, unless they can meet those standards, that is not allowed. And so it is really important that we see these health practices, these insurance companies, these state agencies move towards making sure that their staff are qualified either as interpreters or as bilingual providers themselves. It is also really important, and this is not new, but we continue to emphasize it, that any interpretation services or in-language services or translated documents, they have to be free. You cannot require people to, for example, to pay to bring their own interpreter. They have to be accurate and timely, right? You can't have someone like an interpreter going back and forth and providing, information minutes or hours later. And they have to protect the privacy and independent decision-making ability. So that means that you can't have an interpreter who then goes, maybe an interpreter lives, and this is a big issue for smaller linguistic communities. Let's say you have a smaller Pacific Islander community, and someone in that community is the interpreter. That interpreter is not allowed to go back and, say, hey, so-and-so is diagnosed with diabetes. That is not allowed. That is violating their civil rights. And so it is really important for people to know that interpreters have to adhere by these kind of really basic privacy and decision-making abilities. You can't have interpreters providing their own medical advice, right? And we know this happens. We know interpreters sometimes violate their ethics, and it is important to know that that appears, under this final rule to be a violation. And these are all really important things because we know this happens all the time, and we need to start holding these different systems accountable. Next slide. So I just said that interpreters have to be qualified. What often happens is that doctors will say, well, can't you bring a friend? Or, can't your mom interpret or your daughter interpret or, something like that? And the answer is no, except for very specific situations, such as an emergency, like someone maybe is in a car crash or having a heart attack, right? Someone is in serious medical health and there's not time to get a qualified interpreter. Or if someone actively wants to, right? That does happen. You do see, for example, parents, maybe an older parent with an adult child with limited, and the child is fully bilingual, and the parent wants that child to be their interpreter for the doctor. That's okay, right? That has to be confirmed, right? There are situations where abuse could happen if it is not confirmed by separate qualified interpreters. So you may see, for example, you would say a older Spanish speaking parent and their adult child wants to be their interpreter. They still need to have an interpreter come in and say, are you in Spanish to that adult parent? Yes, I would like my child to be an interpreter without that child in the room, because we do know, sadly, there are cases of elder abuse or abuse of community members, and that language is used as a form of power. And so that is why, even though people might be, oh, why do I have to do this? It's unnecessary. It is important to do that because those situations can be safety or like I mentioned, abuse. Minor children cannot be used to interpret except in an emergency while a qualified interpreter is being located. So this means if you have a child, and that child can never be used. And this is, I continue to be horrified by hearing about situations where children are used to interpret for their parents' medical situations, where children are brought in for to be an interpreter while their parent finds out that they have cancer, or for a OB visit. It is completely inappropriate, but it happens, and doctors have been facilitating this. And so the rule makes very clear that that is not allowed. There's a really wonderful 1 minute new short that's on YouTube called "What Did They Say?" and it's a mom and a young daughter, and the young daughter continues to interpret in various situations for the parent. I really recommend finding that. It's really powerful and just shows just how inappropriate it is to use a child in that situation. That being said, right, those of you who have LEP parents or grandparents, there is a good chance you probably did serve as interpreter for them, or at school or school conferences. And so I really also want to acknowledge that that is, at the same time I'm saying that it's not appropriate, it is very much a part of many people's lives, and I think it is something that is present and hopefully can be moved away from. But it is important to kind of recognize that this is something that is a day-to-day common situation, and sometimes even a preference of parents, even though it is not allowed under civil rights laws, and really an opportunity to protect the children. Next slide. So machine translation, and this is an area we are seeing more and more. So Google Translate, right, and is not allowed to be used without someone verifying it. In Virginia, I use the example because Virginia got famous during the pandemic of providing a Spanish language material that around vaccines, right? And as you probably all saw this news coverage, but I'll just repeat it in case you didn't, that Virginia Department of Health put out a document, and it said in English that vaccination is not required, right? Not mandatory. But the Spanish translation said that vaccination is not necessary. And that was because they used Google Translate. This is common and really unfortunate. We used to see federal government websites that use Google Translate to try to provide information in language. It's convenient, it's cheap, they think it's better than nothing, but also can provide some really bad scenarios where someone assumes uh, machine translated or artificial intelligence translated information is accurate, when it's been proven through this literature about this, even though this is an area of technology that's constantly changing, that it is not. And so what the rule very thankfully says is that a document that is not translated by a human, and this would apply for, like, let's say an AI interpretation as well, must be reviewed by a human. This is going to be something we're going to continue to have to push on, and we're going to have to make sure we're investigating and asking and providing oversight over, making sure the government agencies or health insurance companies or hospitals are not taking shortcuts and trying to save money by using Google Translate or something like that without uh, making sure it's accurate. And I think this is going to be a bit of a culture shift, but it's important to really recognize civil rights are not something that can be outsourced to a machine. And even if we say, there will be companies that say, oh, we're really accurate, we're great, the technology is improving, I do not believe it. And I think we're many years away from being able to trust something that is translated through AI or through something like Google Translate. And so it is great that we have this now very clear regulation or requirement that if you are using Google Translate, you have to have it reviewed by a qualified translator for written materials. And so that is a really important part of the rule. And I hope we continue to see to not see medical information or important information about applying for Medicaid or something like that translated using Google Translate, and having scenarios where people read something in their language that is not true because of that scenario. Next slide. So the standards, this is something that was included in the Obama regulation, then taken out and added back in. Right. There are situations where someone goes to the hospital, and hospitals are not required to provide in-person interpreters. This is something that many people prefer, although not everyone. That's not a requirement. They are allowed to use iPads, right? Many of you, if you've been to the hospital, may have seen the interpreter iPad on wheels that kind of gets rolled around. Or they are allowed to use telephonic interpretation, and some people might prefer that. They might not want the interpreter looking at them, but it has to be of quality, right? So if you're using video interpretation, that you can't have connection problems. You can't have the interpreter glitching out or missing things, or it must be as if that person basically could hear and see everything, both for the patient and for the interpreter. And so the regulations make clear that there must be very clear and strong standards for when telephonic or video interpretation through an iPad or something like that. If you can't understand the interpreter because the internet is poor, that is not meaningful access. It does not meet the standards under this regulation. Next slide. So how is someone supposed to know that they have these language access rights, right? Like someone, especially people who are newer immigrants, might be coming from other countries, but people who have been here for a long time may not know that they have these rights, that they may not know that they can request an interpreter. They may not know that they can request translated documents. They may receive a letter in English, and they may have no idea how to provide, how to get that information. So how do they do it? And so this rule brings back notice requirements. There's kind of two types of notice requirements: is the notice, the general civil rights notice that must be posted, and you see this, and hopefully you'll get it by mail once a year, and it's on websites, and basically says, it has a short summary of the healthcare rights law that provides, we do not discriminate on the basis of sex, disability, national origin, race, etc. There must be also a separate notice of availability. And the availability notice covers language assistance and disability services. And that notice must be in the top 10, 15 languages spoken in the state or states if a hospital or health insurance company operates among multiple states. And so you may receive this, right? If you receive your explanation of benefits from your health insurance company or a hospital bill, this is the thing at the end of that notice, and we have tried, believe me, to get it placed more prominently, but it's always at the end, and it's in the top 15 languages, and it says, in, let's say, Korean or Chinese or Spanish or what have you, in those top 15 languages, if you need help with this language, call this phone number. So they must be posted and they must be provided. And there's a list of the types of documents that these notices must be accompanied. But anything related to coverage, requirements, renewals, payment, cost, anything that is financial implications or legal implications must be accompanied with these notices. I will say we have been working at NILC with our other partners on alternatives. There is a idea of a language access symbol that we're currently working with the Office of Minority Health at HHS about, and hopefully in the next few years we'll see a sort of much like the universal access symbol indicates, where someone in a wheelchair or a physical disability can park. We hope to see a symbol that indicates how to get language access in the next few years. So keep on the lookout for that. We always appreciate partnership. Next slide. And this is the last requirement. I know I've gone through a lot of different requirements. Believe me, it's a good thing that there's so many clear standards. This is something we've been asking for, is much more specificity. In getting to specificity and requirements, if you have 15 or more employees, you have to have someone on staff who's your 1557 coordinator. That person's contact information must be public, must be made available if there is a complaint. So, for example, a hospital must make it clear on their website how to contact the 1557 coordinator. And they have to have clear written policies and procedures. So that must mean, and staff must be trained on those policies and procedures. And it kind of lists which staff have to get trained, but these procedures, for example, must say, all right, how do we know if someone is limited and is proficient? Ideally, people with LEP are not self-identifying, but rather there's a chance to ask someone, or there's an intake process. And when someone does identify that they're LEP and would like an interpreter or translated materials, how do they do so? And they must have that written and detailed. This is a new requirement. Previously, there was a optional encouragement that entities have what are known as language access plans. But this is the first time that it is required that they have some type of written procedures. And so this is going to be a really great tool for advocates or direct service or community members who can request the policies, procedures, and know, all right, is my experience was the fact that I was sort of had to beg for an interpreter, or I had to wait so long, or I was not asked at intake. Does that align with the policies and procedures of the hospital or of the health insurance company or of the Medicaid agency? So that's going to be a really great accountability measure. Next slide. All right, and so this is what I hope everyone can, and I'm happy to clarify or feel free to ask questions, asking me to restate something. Certainly, Deepak and Amber can do so as well. But really, we encourage people to file complaints. Maybe if you want to do it with the hospital or the agency to begin with and see if you can resolve it internally. But if not, within 180 days of the event, so that's why you shouldn't wait too long, you should file a complaint with the HHS Office for Civil Rights. A complaint there's nothing that says what a complaint has to have. NILC filed a pretty detailed complaint about Medicaid unwinding and lack of language access there, and it was long, and our lawyers wrote it, and our lawyers reviewed it. That's not necessary. That I've heard from the Office of Civil Rights staff, a sentence can be a complaint. I was not provided with an interpreter, or the interpreter was incompetent, or I couldn't figure out, I called the phone line and there was no way to figure out how to get information in my language. All of those can be a complaint, and it'll get assigned to one of their civil rights review staff, and they will look into it. I'll say sometimes that can be a little bit of a black box. We are encouraging and working on advocating for more transparency, but that is really the main enforcement mechanism. And certainly, these civil rights will not be respected unless complaints are filed, right? We know health systems really see, it's really unfortunate, but many of them see, and not all of them, there are some that are really good and really want to do well, but many see this just as an expense. Why do I have to help people who speak Spanish? Why don't they just learn English? Or why do I have to help someone with a wheelchair? Or someone else should do that. And they are not going to take this stuff seriously unless there is a negative consequence for them not doing that. And so we definitely really hear, right? There's a reluctance for people to file complaints. You're filing a complaint maybe against your doctor or the people who are providing you with health insurance. There is privacy protections. There are pretty good requirements that make sure that you can't be retaliated against. But it's really important to encourage and work and help to make this law real by filing complaints. And so you can file a complaint both with the hospital, with the health insurance company, with the Medicaid agency, and with the HHS Office for Civil Rights. And so in the kind of final page that we have with resources, would encourage you to kind of click there. Oh, we're going back a little bit. Okay. So this will be the last slide until the resources. Just that don't worry too much about the exact wording. I know this is small text, but in short, for the most part, these requirements are getting rolled out. So the training requirements and having the staff member, they have about half a year to do this. For some of the other requirements, like the taglines, they have a year. So some of the specifics of this are not going to be in effect until actually 1 year and 3 days from now. That is when the rule becomes in effect. But the really basic material requirements, some of them have already been in effect around qualified interpreters, around providing translated materials on demand. Those have been and will be in effect. So some of the more specific ones will be rolling out over the next year, but certainly keep an eye on that. Maybe engage with your local hospitals or public health departments or Medicaid agencies about how they're going to cooperate. It's a great opportunity to ask for a meeting with anyone you'd like to have a meeting with, to ask about their implementation plans. But certainly a year and 3 days from now, all of these will be required. So that's my last slide. I think the next one is resources. Feel free, to use these, since you can't click on links, feel free to use the QR code with your phone or type in that link, linktr.ee/VPLC1557, and that gives you, you'll be able to click on the links in your browser. But happy to answer any questions or do whatever else would be helpful.
Thank you so much, Ben. We'll pause right there. Did we have any questions? Let's see. I hope the Q&A box is working. I can't quite see it on my end. But if you have any questions, do use that. Do submit a question through the Q&A feature on Zoom. But as you're kind of putting those in, I'll just do a couple slides here, just talking about a little bit of the work that we're doing, just kind of to help, one, just helping some of the people that we work with know more about these protections and how to access interpreters and then also working with some clinics as well, so that they're better able to serve clients who are of different nationalities. Let me just put this here. So one thing is that we do have resources available. We are creating some language rights access RAC cards, some called I Speak cards. These are cards that people can use with providers to just explain what languages they speak, and that'll just help facilitate that a little bit easier, so they're able to access interpreters. Also, there's sometimes concern from the similar population, a little bit of overlap with public charge and public charge questions and issues, and we have a lot of resources on that topic as well. And if you have any interest in being more involved in this work, we have, we'd love to partner with you to kind of distribute some of these resources and then get them printed as well. And we have Amber's email there if you would like to learn more about that. And then we also, another thing to just mention is, we did establish last year in response to kind of this growing need statewide for in-person interpreters at places of care, particularly from providers of free and low-cost care. These are the free clinics and health centers in Virginia. A scholarship program where we are providing scholarships to people who are interested in becoming interpreters at these clinics. And so if you know people from the community who are interested in taking advantage of this or partnering us on this program, also feel free to reach out to Amber for that as well. Let's see here. I think we did get one question, Ben. I don't know if you're able to answer this. So what do you think happens to 1557 after the recent SCOTUS decision regarding the Chevron precedent, the statute of limitations?
Well, and I'm saying I'm not a lawyer, although I pretend to be one sometimes because I work for a litigation organization. Here's what I can say. For language access, there is good court precedent case law that says national origin discrimination is language access discrimination. So for the language access portions or the general principle that language access discrimination is not allowed under the Civil Rights Act of 1964 and 1557, that's pretty solid. And I'd say we have not really seen discrimination or litigation against the language access portions of this rule. The sex discrimination, right, have been a real target for litigation, and they're having some case law around, what sex discrimination counts or doesn't count as. Certainly, right, the statute of limitations does bring into, certainly costs are borne as a result of this rule. But we haven't seen a lot of interest in litigating the language access portions. But boy, I mean, the past week or two of Supreme Court precedent has not been good for those who look to the federal government to protect the rights of a vulnerable population. So we'll have to see. Certainly would not be an excuse not to comply, though.
Yeah, thank you so much on that, Ben. I'd also like point another great resource on kind of this kind of final rule, and then other kind of similar rules and then updates as we're kind of seeing them, is the National Health Law Program put out there. So healthlaw.org is the website, and they'll always have great updates as things evolve with different Supreme Court precedents on this issue, but also other issues as well when it comes to the different decisions.
Yes, we linked to their 1557 FAQ in that resource link. So definitely encouraging. I think they did put out statements about Chevron at least. So really recommend them. And Mara Udelman and Help really is the national longstanding expert in my someone I learn a lot from about language access in general.
That's right. Not seeing any additional questions here. Let me just see, check one more time. So we are recording today's webinar, and we'll be posting the slides both in Spanish and English, and be sharing those to everyone who registered. So feel free to reach out to us if you have additional questions. My email is posted here, and back up here to this slide as well. And again, there's that QR code and the Linktree link to get to the different links from Ben at NILC. Just wait another minute and see if we have any other questions. I'm not seeing any other, so well, thank you. Any other last thoughts, Ben, before we sign off here?
No, I mean, language access has been an area of civil rights has been really under-enforced and under-realized. And so really encourage those of you to think about how you can use the opportunity of these new strong regulations to work within your community, work with your government, state government, local government, health systems, to take a much more serious, much more proactive way in making sure that if someone speaks a different language, it is a real health equity issue if they do not receive, if they do not realize their health equity and language access rights under this law. And so hopefully take some inspiration and some ideas for how you might make that happen for real.
Thank you, Ben. We have a few extra minutes. I was going to just share maybe a link to some of the resources that we do have at Enroll Virginia that kind of are relevant in this situation. And let me just see if I can get this here set up. So this is just a sampling of it. We have a lot of resources that are available. So please reach out to us, and Amber at vplc.org can help point you in the direction of one, how to get these and printed, or partnering with them on printing them, but also many of our navigators provide these to different folks. One is these I Speak cards, and we have them actually also available in Spanish and other languages that are kind of the top languages in Virginia. But these are kind of good ways for people that we work with to kind of have access. So when they're going to a clinic, they can use them to get help getting an interpreter. The other one is we have these kind of bilingual posters that just talk about that people can get and apply for financial assistance and help through Virginia's insurance marketplace. And we do have a team of about 17 bilingual navigators who speak a wide variety of languages. And so we do encourage folks to partner with us and reach out to us if we're able to help Virginians in a broad variety of languages kind of access health insurance.
Yeah, those I Speak cards are a great potential policy or procedure that a hospital could have. And they say, our policies that we have I Speak cards or pins on staff who are qualified bilingual staff.
Right.
That is a great way to, you could take that resource from VPLC and say, hey, why don't you do this now that you have to?
Yeah. Well, thank you so much, Ben, for your time today, for coming to talk about this really important topic today, and kind of just continue this journey of helping folks, getting all Virginians get covered, but then also being able to access those services in a meaningful way. And obviously language access, we have found is a very, very important piece of that. So just thank you so much for that. And we'll sign off and just do keep an eye out for recording and the slides from today's webinar. And thank you as well to Amber for kind of interpreting along, and hopefully we kept it slow enough for you to keep up on it. Thank you all.
Thanks for having me.